3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, lawyers. Before Mr. Hebner calls the case, just a brief reminder that while we don't anticipate any technology-related problems, if we should have any, everybody just take a deep breath and we'll pause, and our experts will get us back where we should be. Mr. Hebner, call the case, please.
In re Autumn H.
We'll hear from the appellant.
Good morning, Your Honors.
Morning.
It always strikes me with the gravity of what I'm doing and the difficulty in what I'm doing every time that I argue before the court. I had the opportunity to sit in on a lecture by Judge Dinkins a few years ago, and he tried to help the persons that were listening to understand just how difficult it is for the Court of Appeals to reverse the decision of a trial court, and I understand that. In this case, essentially what I'm asking the court to do is to find that the judgment of the trial court in this case fell outside the spectrum of reasonable judgments, or that the court failed to apply the correct legal standards to the evidence. In this case, it gave the appellant great pause in a few areas, one of which that I want to bring up first is the court's processing and understanding of the testimony of the expert in this case, Dr. Freeman. Dr. Freeman had worked with these parties for quite some time, and at the time of the actual rehearing before the juvenile court judge in this case, he had continued to work with the parties up to and including the day before his testimony was presented. He went through a great deal, as I'm sure your honors have seen, a great deal of care in preparing an original 67-page report, then a further supplement a few months later, and then he continued to work with Mr. Gautier, with the child Autumn, and followed up with the mother very close to the date of the trial. When he was questioned during the trial court proceedings, he indicated that the conclusions that he came to in his original 67-page report were still valid and that he still agreed with those conclusions based on all the follow-up he had done and the supplements that he had done since that time. The court obviously found diametrically opposite to the recommendations that Dr. Freeman made. As some of the case law states, the court doesn't have to go along with the expert. They're not required to. It's purely advisory, but those advisory opinions, have to be acknowledged, have to be understood, have to be cited too. And if there's a ruling diametrically opposite thereof, that there should be a proper explanation for why that's the case. In this case, both before the magistrate and the juvenile court judge, both judges, despite evidence to the contrary, indicated that the reports were old or stale or didn't take into account, certain recently discovered information or recent events. In the case at hand, before the juvenile court judge, that simply couldn't be the case because Dr. Freeman had followed up with the parties in the months, weeks, and even days before the final hearing. That's not cited by the court. That's one of the many concerns that were outlined in the brief in regards to the use of video conferencing, which it does not escape to me the argument that I'm making over video conferencing about the impropriety of using video conferencing, but it does create issues. It does create issues in understanding things. It does create issues in hearing things. And in this case, it created hundreds of those issues. There were hundreds of examples of indiscernible words or difficulties in understanding things and asking to repeat things. And as your honors know, sometimes if you didn't hear something or you didn't understand something, you want to ask those questions. You want to say, hey, I want to make sure that I know what's going on. But sometimes even then things slip through the cracks. So while there were hundreds of examples, there could have been even more, or, things could have been missed entirely and the court didn't even know that they missed it. based on screens freezing up or things dropping out or changes in, the ability of the software to handle the streaming capabilities. And that, and I've tried again here recently to find any more case law to see if the Court of Appeals or Supreme Court had made any further rulings or advisory statements in regards to the use of video conferencing and in issues like this. I wasn't able to find it. That may be my fault. It may be out there and I just can't find it. But the cases that we were able to find were based on telephonic testimony. And in those cases, there are difficulties in telephonic testimony. There are difficulties in video conferencing testimony, but it appears to be most important to the court, the ability of the court to see, hear, understand the testimony, to review the demeanor of the parties or any other witnesses. And those difficulties are a real thing in video conferencing testimony. Those difficulties have a great amount of effect, and the appellant puts forth that it had a great amount of effect in this case. One of the court's concerns, the court had a concern that the father's testimony was too politically correct, or that he had difficulty in answering questions. And honestly, trying to squeeze in together for a trial with witnesses in a forum like this using video conferencing is difficult. Everybody's trying to get on the screen. Everybody's trying to make sure that they can hear what's being asked of them. Everybody's trying to make sure that the court can understand what they're saying. And that doesn't always happen. And it is an imperfect system, but it's an imperfect system that I understand the reason we've had to use it. Obviously we're trying to keep everyone safe. And in this case, Ms. Hatton is in Canada, and there's some difficulties with that as well. But that doesn't take away from the effect that it can have on a case. It doesn't take away from the effect that it can have on the court's ability to judge that testimony. Additionally, Your Honor.
Counsel, do you agree the trial court made a credibility determination in this case?
Yes, Your Honor.
And basically found mother was more credible than father?
Yes, Your Honor, the court did do that. However, and as I noted in my briefs, there were other witnesses who testified about the lack of veracity or the lack of credibility by the mother, and that testimony was absent in reference to the father. Especially the expert Dr. Freeman testified at some length about the lack of veracity that Ms. Hatton had with him, especially in light of the home that she was staying in at the time of trial, and the fact that it was currently up for sale, that it was actively being listed, and things of that nature. And the stability of a parent, the ability for them to have a stable place to live is a very important factor in this case. And the fact that she wasn't upfront and informative to the expert in regards to that, and until challenged, wasn't really upfront with the court.
All right. So is it your position that the proof is sufficient for us to decide the trial court's credibility determinations were in error?
Your Honors, yes, and I know how hard that is to do. It's the highest bar, but in this case, Your Honor, frankly, it looked like the court had more of an issue with the father being on TennCare and felt like somehow he must have lied in order to get TennCare or something like that than anything else. The other comment that the court makes is that his answers were too correct, or they seemed to be too tailored to what the court wanted to hear. Mr. Gautier is an attorney. A lot of times we are careful in the way we speak. That's the nature of the beast. And it's very hard to turn that off, even in your personal life. You choose your words carefully. That's what you've spent your life being trained to do. And it seems as though that was held against him because it wasn't that he gave answers that the court didn't like. It was the court thought, well, he's giving answers that I like too much. And that's difficult to hold against somebody, especially considering that background. But yes, I understand it is a big ask It is a high hurdle to clear. But in this case, there was a great deal more testimony about the lack of veracity from Ms. Hatton than there was for Mr. Gautier. Like I said, it just seemed like the court was somewhat offended that he was on TennCare and thought that he must have lied in some way to do that, but there was no evidence presented of that. And it seemed like an unfair finding, frankly.
Anything else, counsel?
No, Your Honor, I was under 10 seconds. I didn't need to get started on anything else.
That's fine. You have your time for rebuttal.
Thank
We'll
you.
hear from the appellee.
Good morning, Your Honors. My name is Joanne Hatton, and I'm the appellee pro se by financial necessity, not by choice. Thank you for hearing me this morning. This is a relocation case involving myself, a mom from Canada, and the child's father, an attorney from Franklin. I resided in Donaldson, Tennessee for 5 years prior to my relocation back to Canada, when my US visa expired and I was required to return home. The case was originally heard at the magistrate level, and that's where the Dr. Freeman parenting time evaluation took place, and that was in 2019. When Dr. Freeman was called by the appellant to be their expert witness at the time of the de novo hearing with the trial court, which is the case that is before you this morning. That case, that meeting with Dr. Freeman that I had was in February of 2019. That was the only meeting I had with Dr. Freeman. He met with my daughter, who was 3 or 4 at the time, and he was not involved in our case throughout. He called me the morning before the de novo hearing to get an update because he had been called by the appellant as an expert witness. He wasn't following the case. He wasn't involved in our life. I understand the appellant, or the father, had requested a Zoom meeting with Dr. Freeman and the child a few weeks before the de novo hearing, and it states that in the record. Dr. Freeman's testimony also states that he had the opportunity to speak with me last night, which he was referring to the night before the trial. That's in the volume 2 of the transcripts on page 247. And that he had spoken to Autumn by Zoom 3 or 4 weeks earlier for about 15 minutes. When asked who hosted the Zoom meeting, it was the father. Apart from that, he hadn't been involved in the case. Mr. Long brings up a point about the veracity of my self-reporting, which is how Dr. Freeman worded it in his testimony. And he was speaking about the house I was living in at the time. When I moved to Canada, I had to quarantine because of COVID restrictions, and I ended up being at my mother-in-law's house in Canada because I was originally going to stay with my sister, but that didn't work out because of COVID, as her husband was an essential worker and there was some risk. So we ended up at my mother-in-law's lake house because it was vacant, so she offered it to us. It was listed for sale at the time that I moved in. It had been listed for sale throughout the time of the trial, and I told that to Dr. Freeman, which he indicates in his testimony as well. What I didn't bring up was the fact there was an open house scheduled, but as I said, I only spoke to him briefly on the phone the day before court. We mostly talked about Autumn and how she was adjusting. The open house didn't involve me. It was between the owner and the realtor, and it had nothing to do with me. The COVID restrictions where the open houses weren't as we usually understand them. You had to make appointments, and it was just a big process. So I didn't bring up the fact that it was a pending open house. It wasn't on my list of priorities, but I did inform the court and everybody else that the house was listed for sale and had been the entire time. The trial court also made mention of credibility, but that's not brought up in the issues before this court. I understand the appellant's first issue was the factors relating to best interests, and that the judge had somehow made a bulk assumption based on the trial court findings. And that's not true at all. The trial court went through the best interest factors. She found 10 of them relevant to our case. She itemized her finding of fact based on those factors, and she's itemized her conclusions of law based on that and found in favor of the relocation to the mother. She states that the father, she had grave concerns about father's credibility in his inability to answer a question. Almost every question I asked him, he asked for the question to be repeated, and it was not due to technical or video conference difficulties. That was the way he answered questions. Please repeat the question. He did that very, I don't know the percentage, but a lot of the time. I don't know, I'm sure there's reasons people do that. There was some indiscernible words. A handful of them were in the beginning of the case in the trial when we were bringing in the court reporter, and there was some difficulties. Every time that I could find in the record that there was an indiscernible word or something that a person didn't understand and was asked to repeat because of some sort of technical difficulty, the question was repeated and it was understood. And the trial court made no mention or showed any confusion. The trial court knew what was going on. They understood what was happening. When there was, I think there was 2 technical difficulties and there was technical support available. So the trial court technical support handled those difficulties. I think there was a bit of trouble getting Dr. Freeman connected to the Zoom. And there's a handful of indiscernible words while that was going on. It didn't affect the testimony, and the technical support sorted him out, and he testified as we are today, like in this format. So, I'm sure there's indiscernible words in the transcript. That does not automatically mean that the trial court did not understand what was going on. The trial court had command of their courtroom. They had command of the flow of material. They allowed the witnesses to enter and leave as they should. And it didn't seem like the trial court was confused at all. In the appellant's rebuttal, reply brief, he has brought up an issue that wasn't even brought up in his initial brief, that when he called Mr. Gautier, the father, back to do a recross questions at the end of his testimony, that what he intended, and that he called Mr. Gautier, which he referred to Mr. Gautier 80 times throughout the course of the trial. The trial court, if I counted correctly, the trial court referred to the father, Mr. Gautier, over 35 times. I referred to him as Mr. Gautier. His name was Mr. Gautier. Somehow now in the reply brief, the appellate counsel, Mr. Long, has said that he was going to call Mr. Gautier to do a recross, and the trial court cautioned him about the nitpicking that was going on. She mentions that in her final order, that if the father spent more time being cooperative than filing motions and litigations, that it would be better for the child. So when they were going to put Mr. Gautier back on the stand again, the trial court cautioned Mr. Long about that, and they took a recess and they discussed it, and Mr. Long came back and rested. Now in the reply brief, he's suggesting that he was going to call Mr. Gautier, but what he meant was Mr. William Gautier Sr., the father's father, the grandfather, who was not part of any of the cases. And he's suggesting that the trial court was confused, that he meant to call Mr. Gautier, but what he meant was Mr. William Gautier. So there's just no merit to that argument. That didn't happen. He said he felt rushed by the trial court, and there's many examples in the transcripts where the trial court on page 329 of volume 2 asks if there's anyone else, if we need more time. On page 238, I don't want to rush you. I want you to be able to present everything that you would like. We can certainly do another 20 minutes today, but I have some time Friday and Monday, and my calendar has freed up if you'd like it freed up, if that is a possibility as well. The trial court allowed me to put my mother-in-law, call my mother-in-law as a witness to the home I was renting, even though I didn't initially put her on the witness list, and she made time for her to be heard. The trial court was very accommodating with any of the witnesses and extending the time that we needed to make sure everybody got heard and said what they had to say. Oh, she says that again on page 238 of volume 2. Certainly, if you need more time, I'll make room for it. So there was no rush. And if Mr. Long, who's a seasoned attorney, couldn't identify Mr. William Gautier being different than the father, Mr. Gautier, I think he's experienced enough to have been able to do that. So if he didn't call another witness, he didn't call another witness. I find that the trial court findings were correct. Not like I'm a judge, but she did her findings of fact. She made her conclusions of law. She allowed us to relocate, which we did. I would ask that this court affirm her decision. And thank you for hearing me.
Thank you. We'll hear from the appellant in rebuttal. Counsel, are you still muted?
Not now, thank you. As your honors know from reviewing the record, these parties were operating under a 50-50 parenting plan since September of 2016, until the time when Ms. Hatton was allowed by the magistrate to remove to Canada with the party's minor child. The child had spent her entire life up to between a month or 2 months prior to the rehearing before the juvenile court judge in the state of Tennessee. Here she had 4 sisters in addition to her sister Farah. She had Mr. Gautier. She had her paternal grandparents. She had all of the connections in her life. Whereas in Canada, she had no connections. The only connections in Canada would be the mother and her sister Farah. She had not met any other family members that she had there. And the mother was initially allowed to relocate to Canada in part because she said, hey, I have a house, a place to stay with my family. I have a job with my family. I have transportation. I have everything that I need. And then by the time she's relocated to Canada and we come back for the rehearing before the juvenile court judge, she does not have her job. She does not have the place to live that she indicated that she would have. She does not have family close by. She has a vehicle by her testimony. It's unregistered and it's stored 72 miles away. She's not had a driver's license in the preceding 4 years. She was here in the United States for approximately 4 years prior to the move on an expired visa. That's the reason she had to remove to Canada, is she had an expired visa. That visa was allowed to expire. The father demonstrated through his testimony, the testimony of his mother, many of the exhibits that were provided, that there's a very close connection between the father and his daughter, between his daughter Autumn and his other 4 young children. They demonstrated through many pictures together and the testimony that they had very strong connections, and all of Autumn's connections were here. That, along with the testimony of Dr. Freeman, both in regards to the potential alienating behaviors that Ms. Hatton engaged in addition to the fact that Dr. Freeman indicated that there could be some psychiatric harm in removing her from all of her connections in such a way, and the concerns about Ms. Hatton's veracity. Ms. Hatton has demonstrated even here today that she was very open and honest with everyone about the fact that this house was sold. During her testimony at the trial court level, it was even indicated that she had pulled a large for sale sign from the front yard of the property in order to demonstrate, or in order to not allow the father to know that the home was for sale. It was very large. I'm not quite sure how she managed it, but she went to that degree to hide the fact that that house was for sale, to hide the fact that she had even further instability in her housing. That is the grave concern with veracity that Dr. Freeman saw, because she did not self-report that to Dr. Freeman. She did not self-report that to the father, Mr. Gautier. She did not self-report that to the court. That had to be drug out of her through testimony. It had to be drug out of her through testimony that she pulled a for sale sign up out of the yard. This is a parent who was trying to hide her own instability from the court. And that's where some of the concerns with the court's ability to see, hear, or understand the testimony based on the video conferencing comes into play, because there's no
Counsel,
Yes, sir.
in light of that, I mean, you keep referencing that, but our Supreme Court, in reversing this court, held that we're supposed to defer to the credibility determinations, even if it's just a telephone. Trial court gets to listen to it on the telephone. I'm very familiar with their reversing this court because I wrote the opinion they reversed. So the fact that it was not just audio, there was a video. Again, the Supreme Court has made it really very clear to us that we're supposed to defer unless you meet that high burden. And I understand that video conferencing is not perfect, not the preferred way to try a case. But are you suggesting that we simply say that, or we say in effect that every case that was tried by video is going to be suspect?
No, Your Honor, I wouldn't say that. What I would say is, in light of instances like this, where there are hundreds of examples of words that were not heard or things that are asked to be repeated, when it's able to be demonstrated in the record in such a way, and when that demonstration through the record is paired with additional witness testimony that it really isn't even cited in determining the veracity of a witness, that makes it a ripe issue for the court to reverse that credibility determination when all of those factors come together.
Thank you, counsel. Court's thanks to argument from both sides. Ms. Hatton, so you may already understand this, but I want to be sure you understand the process here. Court will take this matter under advisement and we'll come to a decision, and then we'll issue our written opinion and judgment. And we'll send you and Mr. Long a copy of the opinion and the judgment at the same time. Mr. Hivner, if you'll please recess court till our next case this afternoon.
This honorable court is now in recess until 1 p.m.
Thank you, Your Honors.